Welcome to Washington Legal Foundation's media briefing. My name is Glenn Lammi. I am Executive Director and Vice President for Legal Studies here at the Foundation. For those of you not familiar with the Foundation, we are in our 48th year of free enterprise advocacy and education done through a combination of litigation work, filing amicus briefs in federal and state courts, filing regulatory comments, participating in constitutional analysis before legislatures. Also, the program that we're doing today is part of our Legal Studies Division, which publishes on a wide range of issues, puts on programs such as this one, and has a blog, the WLF Legal Pulse. Please check us out at WLF.org when you have some time. So next Tuesday morning, the Supreme Court's going to hear oral arguments from counsel for Laboratory Corporation of America and Luke Davis, as well as a representative from the Solicitor General's office in the case we're going to be discussing today. The question the court teed up is one that WLF's been filing amicus briefs on for quite a few years. The question of whether or not you can have uninjured claimants in a class action, and if so, when the standing of those individuals must be determined. So we were very proud to be the one amicus in support of the certiorari petition. We were kind of surprised that the court granted review, but we were pleasantly surprised. And we're very much looking forward to the arguments. We put together a panel of 3 experts today, 2 of whom their organizations participated as amicus before the court on the merit stage as well. And I will introduce them, and then we will get started. Jeremy Rosen is a partner in the Los Angeles and San Francisco, California offices of the law firm Horvitz and Levy, directed the Pepperdine University School of Law Ninth Circuit Appellate Advocacy Clinic for 6 years. He's also a member of the National Chamber Litigation Center's California Litigation Advisory Committee. Jeremy is counsel of record on an amicus brief filed in support of the petitioner in LabCorp versus Davis by the cities of Beverly Hills and Los Angeles. The link to that brief is available in the chat if you'd like to check it out. Also joining us is Lauren Sheets-Jarrell, who's Vice President and Counsel for Civil Justice Policy at the American Tort Reform Association. In this position, she manages and staffs ATRA's amicus brief program, develops and implements the association's civil justice policy, and manages and has written for ATRA's vaunted Judicial hellholes program. Along with a number of business associations, ATRA filed an amicus brief in Davis as well in support of the petitioner. That one's also available in the chat. And joining us as well on the phone is Andrew Trask. Andy is senior counsel to Shakardi and Bacon, practicing in the firm's Los Angeles and San Francisco offices. Practice focuses on class action, complex litigation in various industries, including the automotive industry and financial services. He's a prolific writer and has co-authored several books on class actions, including the Class Action Playbook and Betting the Company, Complex Negotiation Strategies in Law and Business. He's also authored quite a few papers for WLF, including one we released yesterday on the Davis case, a legal opinion letter. The link to that is also in the chat. If you have any questions for our speakers, please use the Q&A function located in the Zoom webinar toolbar to ask questions. Just want to remind everyone we are recording this. If you are actually watching this as a recording on our YouTube channel, please take a moment to like and subscribe to the channel. So we'll start off with Andy. Your WLF legal opinion letter that I just mentioned did a fantastic job of describing how this case got to the Supreme Court. Can you sort of do a similar setup for us here?
Oh, sure, absolutely. And I apologize for the phone. As it turns out, LA Spectrum today is having issues. So LabCorp is a case about kiosks that are used at the, LabCorp is a testing company. It uses kiosks to check people in. Those kiosks are not accessible to the visually impaired. As it turns out, that has not been a real issue for those people who have showed up checking in for testing who are visually impaired. They tend to prefer going straight up to the desk anyways. But 2 named plaintiffs sued LabCorp, arguing that this violated various accessibility statutes and sought to represent a class. When LabCorp proposed class certification, it pointed out that there really are not many people from the proposed class who were seeking to actually use the kiosks, as opposed to having in-person service instead. And therefore, there were a number of members of the class who were very likely to be not injured at all by the class as it was defined. The lower court certified a class, even though there was evidence there that showed that very few class members had actually ever been required to wait in line or considered themselves inconvenienced. LabCorp appealed to the Ninth Circuit. The Ninth Circuit affirmed in an unpublished decision, which is an unusual move when you're either affirming or denying a 23F petition, because those are only taken as, they're basically taken the way the Supreme Court takes cases, which is that you have the discretion to not take the case at all. So there's no real reason to use a memorandum decision that's not published, at least in the federal appendix. But that's what the Ninth Circuit did here. At that point, LabCorp appealed to the Supreme Court, which has granted certiorari to, as it said, resolve a split among the circuits about whether one may certify a class where a significant number of class members have not been harmed. And that is the question now before the court.
So just to clarify, the question here arises in the context of a class action that seeks damages, not injunctive relief. Why does the type of relief matter when considering whether a class member's standing should be determined prior to class certification?
That's a really good question, and there are several reasons, but they all have to do with the way in which class actions are structured. So under Rule 23B, which determines what your class actions are, there are three different sections that you can certify under. Rule 23B1 is for what are called insufficient fund cases. Those are or limited fund cases. Rule 23B2 allows for injunctive relief, and Rule 23B3 allows for money damages. Now, injunctions require a defendant to either act or not act. So there's not really a question in there of whether or not the action is going to help everybody. You can have an uninjured member of a mandatory Rule 23B2 class, and it doesn't really change the analysis of whether the defendant should be acting to help those injured members or not. You're not giving anybody a windfall. You're not requiring the defendant to do anything additional for these other people. In an indivisible fund case, the defendant is going to be required to pay a certain amount of money if it's found liable. And the reason that you're actually joining a class is that you can allocate that money after the fact to the only people who are entitled to it, if at all. So again, you're not asking anything extra of the defendant if you include uninjured members there. In fact, an indivisible fund case almost requires you to include uninjured people at times. But a Rule 23B3 case doesn't have any limit on the liability. And so what you're basically doing is placing a group in front of the court and saying, if we can prove this one person's case, the defendant has to pay all of these people money. And that's the reason why it's important from a practical standpoint. Now, as it turns out, there's another reason that we can see in the plaintiffs' or the respondents' arguments why it's important. And that is that everybody's pointing to the history of class actions and claiming that class actions have always been this two-step process where first you haul the defendant into court and determine their liability, and then you figure out how much they're going to pay. And they've been pointing to all sorts of rule or pre-Rule 23 cases to show this. Pre-Rule 23 cases were never for money damages. They were always in courts of equity as opposed to courts of law. And so that's another place where actually the kind of relief matters here, because the defendants that the respondents are using apply to the 23B1 and 2 classes, but not to 23B3 classes.
Thanks for that explanation, Andy. I just want to apologize to everyone. I did say that there were materials in the chat. It seems that there is not materials in the chat. I think I must have not checked the right box when I set this up. So when we send out a thank you to everyone who attended or registered, I'll make sure to include links to those materials. So this is an issue that split the circuit courts both before and after the Supreme Court issued its TransUnion decision, and the court has denied certain other cases like this one. Jeremy, why do you think the court decided to hear this particular case?
Well, I mean, I think the obvious answer is that it's a deep and wide circuit split that was not going anywhere. I mean, the Second and Eighth Circuits have held that there's no certification if any class member lacks Article III standing. The First, Third, and DC circuits have applied this sort of de minimis rule, where as long as there's only a de minimis number of uninjured members, you can have a class certification. And then the Seventh, Ninth, and 11th circuits, and we can talk more later about the Ninth Circuit being really all over the place, have not adopted either of those tests and have a looser view on class certification. So you have there, almost every circuit has spoken on this. There's a three-way split and it's not going anywhere. So the Supreme Court was going to have to take the case at some point. And the question is, which one would they take? And it's also an issue that I think it's worth noting that the Supreme Court has long shown an interest in. Starting in 2016 in his concurrence in the Tyson Foods case, Chief Justice Roberts, for the first time, at least at the Supreme Court level, said that Article 3 prohibits courts from ordering relief to uninjured class members. And then in 2021, Glenn, as you just noted in the TransUnion case, the court adopted that rule, but left open the question of whether that determination had to be made at the class certification stage. And so, when they issued the TransUnion opinion, leaving that question open, I think the implied covenant is that they would answer it at some point. And now seems to be as good a time as any, given the continued and deepening circuit split. So I would echo, the surprise from Andy that it was a mem dispo out of the Ninth Circuit, given that they don't take that many cases to begin with in their discretionary role of reviewing class certifications. But I think the Ninth Circuit might have just thought, at least on that question, it's been long established, and they didn't have anything to add. And the Supreme Court decided now was the time to take it.
So the concept of class actions is one that I think the public has a good understanding of, and it's one of the few things that, at least in the law, has sort of taken on a better understanding in the public. Lauren, you've been involved in the Judicial Hellholes project for quite some time. How much have class actions figured into how certain courts or jurisdiction are worthy of the moniker of being a judicial hellhole?
Class action abuse has played a significant role in specific jurisdictions being included in the report, in large part because those courts have allowed what we call no injury class actions, where the class members have suffered no tangible injury, that there was no harm suffered. The plaintiff's lawyers have utilized or exploited plaintiff-friendly statutes or places where they could allege simple technical violations, and the courts are not requiring any proof of injury. So there are three specific jurisdictions that really come to mind that are perennial judicial hellholes. First, we have California, which obviously we're discussing here today. They were number 5 in our report this past December. And specifically, we see this class action abuse in California around ADA litigation, which we'll discuss more here shortly. And then also in the context of consumer protection, specifically targeting the food and beverage industry and labeling requirements. We also see a lot of class action abuse in Illinois around the state's Biometric Information Privacy Act. Here, plaintiffs' lawyers can allege simple technical violations, and there are high statutory damages that are available. And you also see a lot of consumer protection abuse there as well. And then finally, in New York, which this past year was in the top 5 of the report, you have ADA lawsuit abuse, as well as, again, the consumer protection abuse, specifically targeting those food and beverage industry and others.
The brief that ATRA filed, along with the Chamber and other trade groups, noted the proliferation of class actions under the ADA. Can you talk about why that's the case and why such suits are so frequently filed in California, Lauren?
Certainly. So in recent years, we've really seen an explosion of ADA lawsuit filings. We now average more than 10,000 a year nationally. And just by comparison, in 2013, there were fewer than 3,000 ADA lawsuit filings. And an overwhelming percentage of these lawsuits are filed in New York and in California. The two states have rivaled back and forth for that top spot. And in 2023, for example, the most recent data shows that almost 30% of the nation's ADA lawsuits were filed in California. I think they had over 2,300 filed in 2023 alone. And the reason for this is because of the state's Unruh Civil Rights Act, which allows for statutory damages of $4,000 per class member, regardless of whether they were injured. There's that statutory damages that are allowed. And this is a fine that just isn't available in other states. So that's why a vast majority of these lawsuits are being filed in California. And this is why this issue is so important, because this failure to exclude uninjured class members at the certification stage has a force multiplier effect in the state because of those statutory damages that are available.
Jeremy, the brief that you filed for the two cities, Beverly Hills and Los Angeles, puts the larger concerns of class actions into a really unique context. showing that class actions can lead to expensive public funds. Can you talk a little bit about the concerns that the municipalities had that led them to want to participate in this case?
Sure, and I would just add on to begin with Lauren's point about sort of class action abuse and sort of hellhole jurisdictions, in that I think California as well as elsewhere faces, it may not be in terms of the raw number of the ADA lawsuits, but the lawsuits against municipalities for alleged police misconduct are proliferating and becoming a significant problem for class actions that we should all care about, because we're all taxpayers, presumably, of some municipality. And you have these claims that are sort of founded on the seminal Supreme Court Monell decision, sort of challenging the patterns or practice of some particular police department and some policy. But what you end up in these type of class actions is, for the hundreds or thousands of potential, members of the class, they're all highly individualized decisions, because you have to look like what, oftentimes they come up within, stops or arrests. Like, why were they arrested? Was there a legitimate basis for the arrest? Why were they stopped? Was there, a legitimate basis for the stop? All of these are highly fact-based and individualized contentions that need to be sort of have a mini trial on each one. And this Article 3 standing issue is almost always implicated, because in almost any definition of a class of people either who were arrested or stopped, there's going to be some number who did not have their constitutional rights violated when you actually, probably many, depending on the case, when you start looking at sort of the individual facts for each potential class member. And what that means is that there's a huge number in all of these cases of uninjured class members who make it through the definition. This has a lot of profound and serious consequences for municipalities, many of them who self-insure up to a pretty high level. So when you have to start settling these class actions, and that is why a lot of times these class actions are filed, because once they get certified, most defendants, whether they're municipalities or corporations, are sort of forced into having to settle at a very high number, because it's way too risky to then try to go to trial on these certified class actions. But when you're involving municipalities in settlements, this is money that's being directly taken away from public services, whether roads, hiring more police officers, health and healthcare, all the things that cities and municipalities provide when they are having to pay out large, class action settlements. It's a dollar for dollar taking away from the public. So, like the city of Los Angeles, for instance, spends more than $50 million a year on litigation costs and judgments each year. Not all of them are class actions, but a huge number are, and that's money that's coming directly out of providing services to the people of Los Angeles. There could be more police officers, as very relevant in the sad recent times. We could have more more firefighters in Los Angeles if it weren't for class action payouts. And so this is why our amicus brief highlights sort of the unique problem caused by uninjured class members in sort of jacking up the payoffs that municipalities have to make in a way that's we should all be very disturbed about.
Thank you, Jeremy and Lauren, both for sort of creating a context for the importance of this case getting up to the Supreme Court. We're going to talk a little bit now about the arguments that we expect that the parties are going to make. So, Andy, on the side of LabCorp, what sort of legal or constitutional case do you see them making that would require plaintiff's counsel to establish standing at the cert stage?
It's actually, in many ways, a very simple case, and it works like this. Class actions are different than other kinds of lawsuits because you have an individual who's representing an entire group. If they win, the group wins. If they lose, the group loses. The Supreme Court has repeatedly held that the moment that you transition from an individual lawsuit where you win and only you win to you win and a group wins, or vice versa, is the moment of class certification. And that starts with Taylor versus Sturgill and goes through Smith versus Bayer Corp and a number of other holdings in the Roberts Court, many of which, by the way, are 9-0 holdings. So this is something the entire court stands behind. If that's the case, then you shouldn't be representing people who can't be in front of the court once you hit the class certification stage. And the court has held in Lujan that over time, and this is an argument that LabCorp is actually making. The court held in Lujan that basically to demonstrate standing, you have to show with the level of evidence required for the stage that you're at, that everybody or that people before the court have standing. And Walmart versus Dukes has said that you actually have to provide evidence at class certification. So the argument here really is you have to have some kind of evidence that these people have standing. And that's because of the requirements the Supreme Court has already put into place for Article 3 standing.
And Jeremy, what was the Ninth Circuit perspective on Article 3 standing in terms of when it must be established? And does the respondent make those kinds of arguments in its briefs before the Supreme Court? And do you expect they make the same arguments in the oral argument as well?
Yeah, I mean, I think I'll say, I think that the plaintiff's counsel is, very accomplished, and I think did the best job possible of marshaling the arguments in favor of what the Ninth Circuit's rule has been, and sort of the plaintiff's perspective. That said, I think that the petitioner LabCorp's briefing is, I think, more persuasive and correct on the constitutional arguments. But your question about the Ninth Circuit, I alluded to in earlier discussion that the Ninth Circuit sort of has been sort of flip-flopping back and forth on this issue, and over the last number of years, the Ninth Circuit has issued prior opinions sort of coming down on either the sort of the de minimis or no injury, that all class members have to show injury. But then in a 2022 en banc decision called Olean, I may be butchering that, versus Bumblebee Foods, the Ninth Circuit decided that a class could be certified even if it included more than a de minimis number of uninjured class members. And that's sort of the latest sort of proclamation from the Ninth Circuit. I will say that even with that, though, the Ninth Circuit is a bit all over the place. They also issued a fairly recent decision in favor of the city of Los Angeles in a case called Black Lives Matter versus Los Angeles, which was a police misconduct class action involving the arrest of protesters in 2020 after the George Floyd murder. And with the district court certified a very broad class of people who were arrested during those protests. And the Ninth Circuit did, in a published decision, reverse and say that there's a lot of really individualized determinations that would have to be made for each of the individual protesters, because some of them may have been arrested legitimately, some maybe not. It's very difficult to handle that type of claim in a class action. Now, that it didn't expressly deal with the sort of the uninjured class member issue, although it's interesting that the judge who wrote the Black Lives Matter majority, Judge Ken Lee, was one of the dissenters in the Olean en banc decision. So while they are not technically inconsistent, they are sort of, I would say, functionally inconsistent cases in a way, just because they go after the issues sort of differently. Although, as I said, as a technical matter, they're not inconsistent. But I think it shows that the Ninth Circuit has been struggling to come up with sort of a coherent way of explaining how class actions should or shouldn't be certified. And it's a serious issue because a lot of the district courts in California, to take up on one of Lauren's points and sort of their analysis of California as a jurisdiction, the district courts seem to be very gung-ho about certifying all sorts of broad-ranging class actions that they shouldn't be. So I would hope that we would get from the Supreme Court a much clearer rule that will provide some greater uniformity and some important limits on class actions going forward.
The Olean case was one of those that was appealed to the Supreme Court, and the court denied cert. Am I correct about that?
I believe so. And as to that, I think it's just one of that, to me, that's, as an appellate lawyer, that is oftentimes the great mystery. I mean, there was a clear circuit split then on this issue as well, and you would think like an en banc published decision from the Ninth Circuit with a dissent on an issue where there's already a split of authority, where already the Supreme Court has hinted, more than hinted, that this is an issue they care about, as I noted before. You would think that that would be on the sort of the express train for cert being granted, and it wasn't. So what do we know as appellate lawyers? But then you get years later the mem dispo that raises the same issue, it gets granted. I mean, better late than never. I think Olean should have been granted, but it's just one of those things. The Supreme Court has its reasons of when they want to take an issue and what their other workload. I mean, I'm sure there's lots of factors that go into what the vehicle, all these other, other sort of softer considerations. And so for whatever reason, they didn't take that one, but they've taken this one. So
the courts had an aversion to antitrust cases for quite some time, and I think Olean was an antitrust class action, so maybe that was a factor in them not taking it. So, Lauren, one of the things that Jeremy mentioned in terms of the importance of this case and one of the practical concerns about class actions is how it creates pressure for the defendants to settle. Can you talk a little bit more about that particular issue and how you've sort of seen that in doing your research for the judicial hellholes projects?
Yes, when the defendants face extraordinary exposure following a court's certification of an overly broad class, as in here, they face this immense pressure to settle just because of the economic risk that they face. And they face this pressure. It's important to note that they face this pressure even when they are favored on the merits, just because of the sheer expense and to defend themselves against these class actions. I think in our brief, we point out that defending a class action can cost a business over $100 million, and that's not to mention all of the hours and manpower spent during that time. So it really is an uphill battle. And the larger the class, the more the company faces in potential damage liability and litigation costs. So it really does become more economical in most cases to settle these class actions than to launch even a meritorious defense. And an important point that we also made in our brief is just how this coercion and these decisions really hurt the entire economy, because the attorney's fees and the costs that are accrued by the businesses are ultimately passed down. And they're passed down either to consumers in the form of higher prices, or they're passed on to the employees with lower wages. So this class action system that we have right now is really only benefiting one side, and that would be the plaintiff's lawyers, because it's harming the rest of the economy, and that's an important factor in addressing these abuses.
Thanks, Lauren. So, Andy, the respondents and their amici argue that the type of evidence plaintiff's counsel would have to provide at the certification stage, to show that all class members have standing is pretty much akin to making merits arguments, and that's not fair to them. Is that an accurate sort of assessment of the argument of the defendants in this case? And if not, what minimal information must class counsel provide to show that plaintiffs do have standing?
Yeah, the answer is no, it's not. There is a specific inquiry for standing at any point, and it is the injury that you are asserting concrete and redressable? Meaning, is it something more than just a conceptual injury? And if it is more than a conceptual injury, does this lawsuit actually provide the relief that you would need? And that's when you can put it before an Article 3. What the plaintiffs or the respondents here and all of their amici are trying to argue is that once you get to the class certification stage, that apparently means that you have to prove that you're injured in order to be in front of the court. And that's not the case. What you have to prove is that the injury is concrete and redressable. Now, some of that information is the same information that you would have to offer up to show that you are in fact injured as a matter of law and therefore deserve, and therefore can prove liability. But this is sort of a shuffle that the plaintiffs use in class actions all the time to avoid ever having to prove injury on a class-wide basis. There are a number of cases, especially in the Ninth Circuit, that argue that damages inquiries, if they're individualized, cannot preclude certification. And therefore, when defendants raise arguments about injury, the plaintiffs will always say, well, that's really a damages question. And that's something that we've already held doesn't require proof at this point, that you can push that off. And in fact, some of the amicus briefs here argue that what we're really looking at is a standing inquiry that they claim should be put off until the claims process. But if you look at Lujan, what it says is that at the stage that you're at, you have to, with the evidence required at that stage, demonstrate standing, which in this case would be concrete and redressable. And at the class certification stage, what the Ninth Circuit has said in Olin, and I'm with Jeremy, I still don't know how to pronounce that. Sometimes it's Olin, sometimes it's Oleon, depending on who you're talking to. But one of the things that Judge Acuda put into the en banc opinion is that you do have to demonstrate by a preponderance of the evidence that each of the portions of the class certification inquiry have been met. So the standing inquiry at that point would require a preponderance of the evidence, and the Supreme Court has said affirmative evidence, that your injury is both concrete, meaning that it's not simply up in the air the way that Justice Kavanaugh talked about in TransUnion, and that it is traceable back to the defendant in this case, so that if you win, the defendant paying you the damages will in fact take care of that injury. That's all that's required. Everything else after that is rhetoric to try and get you to place it in one of the other boxes that the Ninth Circuit had said are okay to certify.
Jeremy, LabCorp and some of its amici argue that a Rule 23b3 class cannot have a, quote, appreciable number of uninjured members. And in a brief that two of your colleagues from Horvitz and Levy did for the Atlantic Legal Foundation, it argues that classes can have a de minimis number of uninjured plaintiffs. Are you concerned the justices might get hung up on how many plaintiffs without standing is enough or too many? These are sort of very slightly subjective terms, de minimis and appreciable.
If I had to guess, I think no. I think that they're more likely to sort of set forth, and this is I think the appropriate job for a Supreme Court anyway, is they'll set forth what the rule is, whether it could be de minimis, it could be none. My guess is it'll probably be some form of, you know, de minimis or trifle. Can't prevent certification, but anything more than that would, because of the serious Article III standing issues that we talked about. And then it would be, as is always the case after a Supreme Court decision, or almost always the case, it would be remanded back to the Ninth Circuit and then the District Court to potentially to make the specific finding here to apply that new test that the Supreme Court presumably will be adopting to reverse the test used by the Ninth Circuit and the District Court. And then it will be for the lower courts to look here and make the determination, you know, how many uninjured plaintiffs are in this class. You know, it might require, you know, another hearing in the District Court, because I'm not sure that there's, you know, evidence that where this could be resolved. Now, I think it's possible that, you know, there could be a concurring opinion, especially by one of the more conservative justices, who might sort of lay out a marker about how he or she views the record such as it is here in terms of whether or not the new test is met. But I don't expect that the majority opinion will do so. But, you know, then we probably didn't expect that cert would be granted. So, you know, one never knows. But just based on past practice, and since the Ninth Circuit opinion didn't go into this, into a finding here, nor did the District Court order, my guess is that they sort of punt the application and just create the rule of law.
The class definition in this case offers an extremely tenuous concept of harm. Lauren, is there first of all, what is the concept of harm that the plaintiffs are forwarding? And is there a risk that the court's going to constrain its reasoning somehow within the context of such an implausible, sort of unlikely class definition? and that the outcome isn't going to provide the broader guidance that the lower courts need.
So they're focusing on the fact that these plaintiffs were embarrassed by not being able to use these kiosks and sort of an emotional feeling. I think that we certainly run the risk, but the hope is that given the deep circuit splits that exist and the fact that we're just seeing this broader legal trend of uninjured class members comprising the classes and the abuse that's occurring, that we're hopeful that the court will actually address this broader issue and not make it case specific. Our brief stressed how this is a time of prolific litigation, and so it really is essential for the court to step in and insist on the application of formal rules of standing in these class actions. To that point, in the past month, ATRA has filed multiple amicus briefs in federal circuit courts over this very issue of uninjured class members and Article 3 standing. Now, all to vary, there's different theories being presented in those cases, but it just speaks to the point that this really is an issue that the court needs to recognize the importance of and provide some clear guidance for the lower courts and require that strict or rigorous review.
Andy, in your WLF legal opinion letter, you talk a little bit about some of the information in the record that indicates that some of these plaintiffs weren't actually harmed. Can you talk a little bit about that?
Oh, sure. Yes. So in the record, at least as it was presented at certiorari, and it's interesting because, of course, the briefing after that gets into what's properly in the record and what's not. But what's in the record at the time is that 1/3 of everyone who used the kiosks didn't mind if they didn't have the kiosk and also went to a person up front, and that there were no complaints aside from the 2 class action plaintiffs from any visually impaired people asking for further access to the kiosks or complaining about having to use the people up front at self-serve or not self-serve. So those are 2 pieces of evidence that were already in the record. From there, you can draw a logical inference as well that if you have a sort of a random distribution, which I think is always a fair assumption to make when you're talking about class actions, that in the absence of evidence, you're just going to see a random distribution where there's some yeses, some no's, some complaints, some nots. That the fact that there were no complaints means that most people probably were not bothered in one direction or the other. So that's the record that's actually in front of the court at this point, that there are 2 named plaintiffs, that there were no other complaints, and that 1/3 of the class in general, 1/3 of users, not even the class of visually impaired people, didn't mind whether or not they had kiosk access.
Stick with you for a second.
Does that
Andy.
answer the question?
Yeah, thank you very much. Andy, can you talk a little bit about the brief that the Office of the Solicitor General filed in support of neither party and the fact that they're going to be able to do divided argument here? Does the brief contain any arguments that you think might sway the court in one direction or the other? It was interesting that it was filed in support of neither party, but it was most of the arguments seemed to be indicating that standing issue is something the court needs to deal with right up front.
Yeah, it's I'll start with the part that I think is not sort of pro-defendant, and I don't know whether it will sway the court. I don't think it will, but given the fact that there's now an argument that cert was improvidently granted, it could be a way for the court to get through this without making a substantive decision. And that is the final argument that the government makes, is that, from what I can tell from reading it, that basically you could just GVR this, meaning you granted certiorari, now you can vacate the class certification decision and simply remand it for better adherence to the en banc opinion in Olean. I think that's unlikely only because it's very difficult to simply, this has come up a number of times, especially in the Ninth Circuit, but also with the rule reforms to Rule 702 and scientific evidence. It's very difficult to just tell a court to follow the rule only better this time, which is essentially what that argument would be saying is, without getting into the substance, just send it back down and tell them to do it better. And without guidance, that doesn't actually give you a lot. Where I think the government brief does a very good job, and I think it could be very persuasive, is in 2 spots. One of which I'm very clearly biased towards because I've been saying it throughout this entire panel, which is the government brief very clearly walks through the logic of both Lujan and Dukes when they're combined, which is Lujan says you absolutely have to demonstrate standing at the level of the particular stage of the litigation that you're at, and Duke says affirmative evidence. And so bam, there you have, you need affirmative evidence of standing. And that's very clear. I think it's just on a technical level, absolutely correct. And it's something that Gupta-Wessler in particular dances around, but ultimately concedes still is the case. And then their question is just how burdensome does that have to be? The other place that I think that the government's brief may be persuasive for the court in a way that would help business interests is that it kind of takes a bit of Gupta-Wessler's brief and flips it against itself. Gupta-Wessler's brief, and they're the brief for the respondents, makes an argument at one point that there's really not a big issue here because you can always carve out the people who don't have standing at some point. And the only question is whether you have to do it at certification. And then their amici get into the whole question, particularly the civil procedure professors, of whether this is a question of size of the class that's uninjured, or really a question of the ease of excision, by which they mean how easy is it to carve out that uninjured spot. And what both the Gupta-Wessler brief and the professor briefs kind of overlook is that to the extent that this can be done at any time, and to the extent it's a question of ease, it's going to get done at certification. And so the real question becomes, what happens when you have a class where it is difficult to separate out injured from uninjured people? And that would require inquiries into individual standing or lots of different factual scenarios. And under Rule 23b3, that's pretty clearly an example of a class that should not be certified. And the government brief is very good about coming out and saying, if you're at a point where you can't easily carve out the people who have standing from the people who don't, then it's not a certifiable class, because that alone says that it doesn't meet the requirements of Rule 23b3. And I think that's the place where a lot of these issues get murky, only because the Ninth Circuit has made them murky over time in a way some other circuits haven't. The Ninth Circuit over time, more than other circuits, has conflated the conceptions of injury and damages to the point where making an injury argument in front of the Ninth Circuit very frequently leads to a judge who wants to certify a class saying, well, that's really a damages argument, isn't it? And we've got law that says that if it's a damages argument, we don't have to worry about it at certification. And then you've also got a question about how hard it's supposed to be and how much evidence you're supposed to present. Really, it's a fairly clean argument the way the government frames it. And this is what I think might prove very attractive to some of these justices, that when you're sitting at certification, you have to have affirmative evidence of, among other things, standing. Standing is concrete and redressable. If you don't have that affirmative evidence, then people don't have standing. You shouldn't be giving them relief. If you can't carve them out of the class, then you don't have a class that can be certified, because you can't, on a class-wide basis, determine injury. And that's really what this all comes down to. And so the question, I think, will just be whether or not that appeals to enough of the Supreme Court justices, as opposed to various other ways of formulating the question. But I think that's the simplest way of getting at this. And I think the government brief does an especially good job of boiling it down.
But it's interesting that this case comes to the court in the context of a class action under a federal law, and the vast majority of litigation where there's class action is under state law for the most part. So I don't know if that's going to make any difference, or if the Solicitor General's involvement is in part because the ADA is involved here. But it's kind of ironic and not something that I've heard a lot talked about. So I want to get each of your thoughts. So go ahead, Andy. I'm sorry.
Oh, yeah, I was going to say that is, I agree completely. And I think that it may actually help a little bit. And it might be one of the reasons the court didn't take some of the other cases, not Olin, because that, I think you're right, is an antitrust case. But the court here has a special competence to proclaim on every issue of this, substantive and procedural, in a way that it doesn't always, if part of the question is how do you interpret a state's tort, contract, or implied warranty law.
Right. So I want to get each of your thoughts on which justices people should be keeping an eye on during the oral argument. So I'll start with Lauren. Are there particular justices that you think will have some interesting questions?
I'll defer to the appellate lawyers on the call who follow this stuff a little closer. I think, it will be interesting to see how the conservative justices fall on this. But again, I'll defer to Jeremy and to Andy on this question.
Jeremy?
I think one justice to look at is Justice Thomas, only because the plaintiffs have made a case to try to have cert dismissed as improvidently granted, and at least some of the arguments that they've made were arguments that Justice Thomas alluded to in a recent concurring opinion. Now, I don't think that I think the facts here are different from that one, and blanking on the name of that opinion at the moment. But I think that to the extent that anyone might be concerned about those, I think Justice Thomas might be. So that would be sort of one person who I would look to.
Andy, any thoughts on that?
Thomas always worth watching. The one I think is going to be most worth watching, and this may sound like a bit of a surprise, is Justice Kagan. And my reasoning for that is that Justice Kagan, granted it was 12 years ago at this point, but she wrote the 9-0 opinion in Smith versus Bear Corporation, which is the one that has the clearest statement that the moment where a case transitions from being an individual case to a class action with a class is the moment of certification. And so I think watching her questions will tell you whether or not she's willing to commit to that logic to the point where it actually leads to a denial of class certification. And that, I think, is going to be the moment when you know whether or not what you have is a 5-4, a 6-3, or something even larger. The other two that I would probably keep an eye on are Kavanaugh, because he wrote the TransUnion opinion, and Roberts, because he tends to occupy what used to be the Justice Kennedy spot of being sort of the middle in these debates. And he's the one who, as Jeremy rightly pointed out, wrote the concurrence in Tyson Foods that basically recognized this issue for the first time.
And I'll just add on the Justice Kagan point that Andy made, which I think is very insightful. That sort of ties into, Glenn, your prior question about whether we think that they'll sort of apply the standard here and to try to figure out, like, is there, how many uninjured class members that exist or not. And I think, especially if someone like Justice Kagan, who I think might well be on the defense side on this at a broad level, to get a maximum vote count would generally mean not sort of applying the test, but to sort of setting the test and sending it back down. Because I think when you start trying to apply, sometimes the devil is in the details, and that's where you could start losing votes. And so, I think to get like a 7-2 or 8-1, which I think is theoretically possible, hard, but possible. And Justice Kagan would be the key on that. I agree. But that also just counsels towards a more sort of general opinion, setting forth the law and not applying it, which is why you might have a conservative justice who's very interested in this having a concurring opinion, setting out their view on how the lower court should apply it.
Just a reminder, we're happy to have questions from our audience. If you want to type those into the Q&A, please go ahead. So, Jeremy, if a justice were to ask counsel for LabCorp whether a ruling in their favor would be the end of class actions as we know it, or at least Rule 23b3 class actions, what's a good answer to that?
No, because class actions are still very economically beneficial to plaintiffs' lawyers and to plaintiffs. So I think there will always be attempts to bring class actions for all the reasons that class actions are said to be a useful device. I think what a ruling for the defense here will do is require narrower classes and more thoughtful classes, and to me that is actually a good thing, because you would then be using the class action vehicle for sort of a more proper purpose.
Lauren, what would be an ideal outcome here in the opinion of the American Tort Reform Association?
From our perspective, we hope the court reverses the lower court's decision to certify the class and then sets out a requirement for the courts to do a rigorous analysis of both Article 3 standing and Rule 23 requirements prior to the class certification This will ensure that the parties don't waste time and money on litigation, all to find out at the end that they're unharmed class members that are a part of the class, which then will also prevent the defendants from feeling that pressure we talked about earlier for settlement because of the overwhelming size of a class that includes unharmed members.
Andy, as an attorney who defends class actions, what would be a good outcome for the law and sort of for the arguments that you usually make in these kind of class action situations here?
I think Lauren's is pretty close. What I would say is I would want to see three things. One, you can't have a class that necessarily includes uninjured class members, which is another piece I'm grabbing from the government's brief. If you can't figure out a way to excise them, then that's the wrong class definition. Two, there is a standard of affirmative evidence or standing at class certification that matches Walmart versus Dukes. Again, from the government briefing. And then I think those are basically the two pieces that I would want to see. If there were some language, because sometimes the justices will kind of get off on whatever their pets are. If there's some language in there about how an injury is not the same as damages, I think that would be fantastic. That would be lovely to have to rebut some of the sloppier arguments that get made. But that's kind of like way out there. That's if you're giving me a lamp and a genie and asking me how I want the opinion to look.
Right. Thank you very much. Seeing that we don't have any questions from the audience, I want to bring our proceedings to a close. Thank you, Jeremy and Lauren and Andy, for joining us today and providing your insights. And thanks for the participants on Zoom as well. It's great that we all get a chance to listen to these arguments. For those of us who've been around a while, that wasn't always the case. So it's wonderful to be able to have this kind of discussion and then actually be able to hear what the justices are asking without having to sit down and read the transcript. So everybody should enjoy tuning in. And again, thank you very much for joining us today. There's be a survey when you close the webinar window. If you could take 2 minutes to do that, I'd really appreciate it. And again, thank you everyone for joining us.